Hilchos Shevuos Perek Chi, the Laws of Oaths, Chapter 9. We now move on to exploring the fourth type of oath. In Chapter 1, the Rambam said all oaths can be divided into one of four categories. Shevuos Bitoy, the standard oath. Shevuos Shav, the useless oath. Shevuos HaPikadon, the oath of deposit. And Shevuos HaEdus, that's the one we're learning about today, the oath of testimony. The basic scenario of an oath of testimony goes as follows. There's a person who's having a court case and he believes that there's two people who could help him by testifying for him in court. He comes over to them and he says, listen, I need you guys to come and testify for me in court. I know you know information about the case. And they deny knowledge of the testimony, plus they swear to their denial. And then it turns out that it's false. They do know the testimony. That's called Shevuos HaEdus. They made a false oath of testimony and they're held liable for it. Now, that's the basic scenario. There are certain variations, and all in all, the Rambam is going to tell us that there are 10 conditions that have to be met before witnesses can be held accountable for a Shevuos HaEdus. That's what we're going to be learning about for the first half of this chapter, is those 10 conditions that make Shevuos HaEdus possible. But again, remember the general scenario, it's two witnesses who are being charged with knowledge of testimony. They deny that knowledge, swear to that denial, turns out that it's false, now they're held liable. And with that, we approach the perek itself. Says the Rambam, HaTeveya Eidov Lehoid Lo Eidus. A person charges witnesses, he demands witnesses to come and say testimony for him. And the type of testimony that he's asking them to say is a type sheyischayev hanitva be'eduson levada, that would obligate the defendant just by their testimony alone. These are very important words. They're going to be clarified in halacha number 4. Just by their testimony alone, that's going to require the defendant litin leteveya zeh mamin hamitaltel, to pay the plaintiff movable property. So again, the money in question is movable property, and the money in question is such that the witnesses on their own are enough to force the defendant to transfer the money. I'm going to give a little spoiler alert. The Rambam over here is coming to exclude a case of knas. Yesterday we had, and the day before, the concepts of restitutional payment and punitive fine. Restitutional payment means payment that matches the crime. A fine means an arbitrary payment that's either more or less than the crime. One of the differences between mammon and knas is that mammon you pay if you admit it on your own. But a knas, if you come forward and admit to owing a knas, you don't have to pay it. So if the money in question in the court case was a case of mammon, then all you need is the witnesses alone to say their testimony. When you testify that somebody owes somebody else money, boom, that creates the obligation. But if the case in question were a case of knas, then really the witnesses on their own aren't really inherently what are making the obligation. Because were the defendant to admit owing the money, he'd be exempt, even if the witnesses came afterwards. And so really what needs to happen is that the defendant first needs to deny the claim, and then the witnesses should refute his denial. So since in that case it's not be'edusan levada, the obligation wouldn't come about on account of their testimony alone, doesn't fit this bill. Doesn't go into the category of Shevuos HaEdus, as the Rambam will soon say in more detail. That's why he says it with these words over here. So again, we repeat. A person demands witnesses to come say testimony that is of the nature that it would, just by their testimony alone, require the defendant to pay movable property. The kafru be'edusan v'nishbu, and they denied knowing testimony, and they swore to that denial. Bein shenishbu bebezdin, bein shenishbu chutz lebezdin, and whether or not they swore in court, hare'elu chayavin mishum shvuas ha'edus, they're held liable for making a false oath of testimony, sharei hifsidu mamin bikfirasam, because by virtue of their denial, they've lost this plaintiff money. Would they have come to court? They would have helped. Now that they didn't, or they denied knowing the testimony, they caused them to lose money. Similarly, if the plaintiff adjured them, he didn't come and ask them to say testimony and they responded with an oath. He comes with an oath. Hey guys, I put you under oath that you should come and testify for me. And all they responded with was a denial. Even if they didn't swear on their own, they didn't even answer amen to acknowledge his oath. As long as they denied his claim and it turns out that it's false, they're held liable. Now, in this last case, where he began with adjuring them, that adjuring has to take place in a court. If they're the ones that are swearing, doesn't matter if it's in a court or not. But if he's beginning the oath, it has to be done in a court. Additionally, even where he's not beginning the oath, even in the case where they're swearing, the initial denial of the knowledge of testimony has to happen in court. Witnesses are not held liable for a false testimony oath unless they deny first in court. Wherever the oath takes place. They make an oath, he adjures them, in court, out of court, doesn't matter. The oath can happen wherever it is. The denial has to happen only in a court. Shenemar, because the verse which describes the sin of not saying testimony when you know it, it says, Im lo yagid v'nasa avaynai. If he doesn't talk, then he bears the sin. Which means, makim sheyagid v'yayil, hu sheim lo yagid sham yischayev. Only in a place where talking would help, does not talking get you to bear a sin. Where does talking help? Only in a court. Therefore, denial has to be in a court. So, if you think about it, usually the scenario will play itself out in a court. That's how it would happen, because otherwise it's a bit of a funny case. He'll have to ask them to testify in court, they'll deny the knowledge of the testimony, then they can walk out of the court and then swear to their denial later, and they'd still be liable. But that's the law. The law is the denial has to take place in court, the oath can be anywhere in court or out of court. Halacha Gimel, Tavan be'edos she'eino mechayeves mamain. If the plaintiff charged them to come say testimony about a case that doesn't concern money at all, come testify about my genealogical status. I want to make sure that I'm a Kohen or a Levi. Or to say testimony about a case involving real estate or slaves or contracts, documents. The kafru v'nishbu, and they denied knowing testimony about these cases and swore to their denial. P'turin mishvuas ha'edos, if it's revealed that they're speaking falsely, they're exempt from an oath of testimony. She'ein chayavin elal kfiras eidos mamain, because witnesses are only held accountable for denying knowledge of testimony concerning property such she'daimel lepikadon u'sasumis yad v'gezel v'aveda she'partan akasav b'parsha. It has to be money of a nature that's similar to the object chosen in the Torah as examples. Deposit, loan, robbed object, lost objects, she'ein mitaltalin shegufan mamain, which are movable property. They have inherent value. And immediately upon their testimony, it would force one to hand over to the other. Land is not like that. Land isn't a handable thing. It's there. Whoever owns it, owns it. Slaves are like real estate. Documents have no inherent value. They're only there to prove something else. Therefore, they're excluded from the laws governing Shevuos ha'edus. And even if they denied knowing testimony about it, if they spoke falsely, they're not held liable. Similarly, if somebody would adjure witnesses to come testify about a punitive fine and they denied knowing knowledge about that, if it's revealed that they're speaking falsely, they're exempt from having made a false oath of testimony. Here comes what I said before in the beginning of halacha number 1. Had the defendant come forward and agreed to owing the knas payment, yipater milashalem, he would be exempt immediately from paying. Even if later the witnesses would come and testify, doesn't matter. Again, those words. Turns out the witnesses on their own, their testimony alone didn't oblige the payment. It's the testimony together with the denial of the defendant that creates the obligation. And since had he admitted, their testimony wouldn't help. And if they denied and swore to the denial of such a testimony, they are exempt. Halacha hey, what if the case involves both mamain and knas? The plaintiff comes and says, I adjure you, that you should come and testify, that you should testify that this guy owes me double payment for thievery or 4 or 5 times payment for stealing and slaughtering and selling an animal of mine. The kafru, and they denied knowledge of such testimony. Chayavin b'shvuas ha'edus, they are liable for having made a false oath of testimony because of the restitutional part, the principle. Not because of the double payment, that's punitive fine, but part of the claim involved regular mamain. So for denying that, they're liable. Similarly, if the plaintiff adjured them, that they should come testify, that somebody raped or seduced his daughter, rape or seduction incurs both restitutional payment and punitive fines. So the kafru, if they denied knowing such testimony, they are liable for having made a false oath of testimony. Because of the humiliation payments, the blemish payments, which even if the defendant agrees to having committed the crime, he would have to pay. Not because of the fine. The fine, if he had agreed to, he wouldn't have to pay. But there's a part of the claim which involves mammon. They're held liable for that. And the same applies to all similar cases. Halacha Vav, another condition about testimony oaths. Witnesses are only held accountable for making a false oath of testimony until they deny and swear after being accosted, after being demanded by the plaintiff or by his attorney, his agent themselves. But if they go ahead and swear on their own initiative before being demanded, they're exempt, even if what they said is false. They're exempt for having made a false oath of testimony. Ketzad, what does this look like? If two people see the plaintiff walking behind them, they turn around and they say, why you're following us? We swear, we don't know any testimony for you. The guy didn't say anything. They came out on their own and swore. If it's discovered that they're speaking falsely, they're exempt for having made a false oath of testimony. Because the plaintiff didn't demand them to come say testimony. They went ahead and swore on their own initiative. Similarly, if it wasn't the plaintiff, it was the defendant. The defendant comes over to two guys and he says, look, I adjure you, if you know any testimony that can help the plaintiff, come to court, say it. The kafir, they denied knowing any testimony, and it's revealed that they're speaking falsely. They're exempt from having made a false oath of testimony. It has to be the plaintiff that demands them to come. Needless to say, if it was not the plaintiff, not the defendant, a random guy, if somebody adjures them, they should come and testify that somebody owes somebody money. The kafir and the denied knowing testimony. And of course they're exempt. The person that's demanding them come to say testimony isn't even one of the litigants. He's not in the court case. Another condition, if the oath comes before the knowledge of the testimony, if the oath is revealed to be false, they are exempt from the false oath of testimony. Because the verse about the Shevuos HaEdos, it says, V'shama kol olah v'hu eid. He hears the voice of the oath, he's being adjured, and he was already a witness. Which means, shekadma eidos l'shvua le'shekadma shvua le'eidos. The situation must be one where the testimony's knowledge came before the oath, not where the oath came before the testimony's knowledge. What's an example of that? Ketzad, what does this look like? Mashbi'a ani aleichem, a guy comes over to two guys and he says, listen, I adjure you, down the line, if you ever know testimony about me, you must come to court and say testimony for me. V'amru amen, and they accepted the oath. They said amen. And indeed later they became aware of testimony that could help him out. And then he demanded that they come say testimony. The kafru boy, and they denied knowing the testimony. So then retroactively, the oath which they made earlier turns out to be false. Nevertheless, they're exempt from that false oath, because the oath came before the knowledge of the testimony. Halacha tes, another condition, witnesses do not become liable for a false testimony oath until they are singled out by the plaintiff who adjures them, or they swear in response to being singled out. Ketzad, what's considered singled out or not singled out? Amad bebeis hakneses. A guy gets up in shul, v'amar, and he says, Mashbi'ani kol mi sheyeda li edus sheyavi v'yoid li. I adjure, anybody who knows testimony about me should come, say testimony. V'anu kulam amen. Everybody answered amen. Everybody accepted the oath. Ve'edav bichlalam, including two people who could actually be his potential witnesses. But then after making this public ceremony oath, he goes over to those guys, asks them to come, and they deny knowing testimony. They are exempt from making a false oath. In the moment of the oath, he hadn't singled them out. He just said, everybody who knows. But if he said, changed his wording slightly, I adjure everyone standing here. That's already enough to be called singled out. I adjure everyone standing here. If they know testimony, they should come and testify for me. And the witnesses were included in that crowd. They kafru, and then later when they were approached, they denied knowing testimony. They are liable for making a false oath of testimony because he singled them out. He said, everyone standing here, included in everybody else, was those two guys. Similarly, if he would have told the witnesses before, he approached them before, he singled them out before the oath. Plainly come, testify for me that this guy owes me a money, 100 zuz. Then he stands up in shul. And he says, he adjures, anybody who knows testimony should come testify. Even though he didn't use the singled out language, but because he singled them out before, if they didn't come and they didn't testify, they would be liable. Because he demanded them first, individually. However, in this case, some preconditions need to be met. The witnesses had to have been present during the oath, of course, and there had to be a court there. But if they weren't in front of the court, so then when you're not in front of the court, you can't just accept an oath with no verbal acceptance. If they had answered amen, then if they go later and deny in court, then they'd be liable for an oath. But if they didn't answer amen, they never accepted it, so the whole oath is moot, and they're not liable to having made a false oath. When you adjure witnesses to come, doesn't matter if you use the classic structure of an oath, or he says to them, I command you by an oath, I forbid you by an oath. In all these cases, they're liable. Just with, provided that he uses in the oath, in the formulation of the oath, he uses God's name, or at least one of his nicknames. As we explained in chapter 2, that every oath, even though I kept on saying it, I swear, but it actually begins with, I swear by the name of God, or I adjure you in the name of God, that X, Y, and Z. So that condition also applies to the oath of testimony. Finally, the last condition is, witnesses are only liable till they're adjured in a language they understand. They must be aware of what they're accepting or denying. So behold, you have learned. There are 10 things in total, 10 conditions that are required to be met for witnesses to be liable to a false oath of testimony. They are the following. They have to be demanded by the plaintiff. He needs to approach them. It's a bit out of order over here. It has to be, it's in order. Charged by the plaintiff, has to be concerning restitutional payments. It has to be movable property. It has to be their testimony alone powerful enough to get the money out. They have to say their denial after being charged by the plaintiff. They have to deny in court. God's name must be involved in the oath. Their knowledge of a testimony has to precede the actual oath. They have to be singled out during the oath or during the charge. So they have to have the language which they recognize. It's quite unusual for the Rambam. He just said all the 10 conditions, now he kind of relists them. So the Rebbe says perhaps maybe it is a little usual that the Rambam likes to summarize lists, but on a mystical level, the Rambam may be communicating a message for the Jewish people. We're called God's witnesses, atem eidai. We're supposed to be the witnesses testifying to his existence. The whole idea of testimony is only valid in a case where the information isn't obvious. If it's obvious, you don't need testimony. So same thing with God. He's not obvious in the world. We need to testify to his existence. We need to announce it loud and proud. And the power to do that is asara dvarim, the 10 things. 10 things referring to the asaras hadibres, the experience of the giving of the Torah on Mount Sinai when God modeled what it looks like to bring heaven down to earth. Then it was revealed for a moment. But we, with the power of those 10 things in the study of Torah and doing mitzvahs, can bring that to the current reality as well, testifying and making public the knowledge of Hashem's existence. Halacha Yudalid Kol Mokem Sha'amarnu Pater. In any of the last 13 halachot where we said that witnesses are exempt from having made a false oath of testimony, doesn't mean they're all the way off the hook. Pater mishvuas ha'edos avol chayav b'shvuas bitei. They may be exempt for a testimony oath, but not for a regular oath. Bottom line is you swore falsely. Assuming they made an oath, or they answered amen if they were adjured, they swore falsely. Yeah, we can't hold you accountable in this specific case, but you in general made a false oath. But if somebody is obligated, liable for making a false testimony oath, even though he swore falsely, and he did it purposely, we're not going to hold you accountable at the same time for also having made a false standard oath. In other words, you only get one liability. You only get held accountable for making the false testimony oath. Because the Torah differentiates them. Torah differentiates the testimony oath from the regular oath, to give it a unique law. The unique law is that whether you're purposeful or inadvertent, you always only bring a sacrifice, no lashes. As it says, you only get punished for one of these. You can only make him liable for one type of oaths, not for two, to the extent of holding him liable for both testimony oath and standard. No, you only pick one, either testimony or standard. Halacha Tezvav, the Rambam repeats the principles that he repeated when it came to the laws of the deposit oath, and that is that whenever you make a general denial, even in response to a specific claim, you're only held liable once. But if you make a specific denial to a specific claim, you're held liable for each individual denial. In a number of scenarios. Mashbi'ani aleichem, I adjure you, says the plaintiff. Im lo tavayu v'ta'idu li, that you must come and testify. Sheyesh li bi'ad pleini pikadon u'sesum esyad gezel va'aveda. You should come testify that I am owed a deposit, a loan, a robbed object, and a stolen object. So 4 specifics. And the witnesses respond, Shvua she'enanu yedim lecha edus. We swear we don't know you any testimony. General denial. Enan chayavin ala achas, only liable once. Shvua she'enanu yedim lecha edus. She'esh lecha be'ad pleini. Pikadon u'sesum esyad gezel va'aveda. But if they respond in specifics, we swear we don't know any testimony about the deposit, loan, robbed, and stolen object, and lost object. Chayavin al kol achas v'achas. And they're liable for each one, because they denied each one specifically. Similarly, Mashbi'ani aleichem, I adjure you, says the plaintiff. You must come and testify for me that this guy owes me wheat, barley, and spelt. We swear we don't owe you any testimony. General denial, only one liability. We swear we don't know testimony for wheat, barley, and spelt. They denied all 3 specifics. They're liable for each one individually. If it wasn't just one person saying multiple things, it was multiple people demanding that they come say testimony. But Amru, and they said, we swear we don't know you all testimony. They included them all in one. Only liable once. If they single them out, we swear we don't know you testimony, not you, not you. You're liable for each one, as we explained with the deposit oath yesterday. Until now, we've been talking about a case, classic case, where the person wants you to testify and you swear that you don't know testimony. What if it's the opposite? You swear to a friend that you know testimony and it turns out that you don't. Hareze potter. Interestingly, you're totally exempt. There's no testimony oath and there's no false standard oath. To be in the category of a standard oath, it has to be able to go both ways, both negative and positive. The negative element of this oath, I don't know you testimony, is the testimony oath. That's not in the category of standard oath. That's testimony oath. Since the negative element is not categorized as a standard oath, so to the positive element where you swear that you do know testimony, doesn't count for a standard oath. It's in neither category, so you're totally absolved. But of course, Davar Baruch, it's very clear, says the Rambam, that if you're talking about an issue of testimony in the past, I swear that I testified for you. and really he didn't. I swear I didn't testify for you, or really he did. You're only liable for a false standard oath. There's no testimony oath here at all. Testimony oath is only futuristic. This is going back in the past. It's a classic standard oath, and it can go both ways, positive and negative. Therefore, you're only held liable for a Shevuos bitoy, but for a testimony oath, you're totally absolved.